This video is the 17th in a series of 17 videos on the subject of appointing custody evaluators and the appointment of guardians ad litem, or GALs for short, in Utah child custody cases. You do not have to view all 17 videos to benefit from this series. Watch as many or as few as you like. The purpose of this series is to make the case for the proposition that an interview by the judge is a faster, more accurate, more particular, more reliable, and less expensive form of evidence than what a GAL and/or custody evaluator provides. Even if private guardians ad litem work diligently and find a lot of useful information, there is no way to know that, because guardians ad litem are not required to furnish any proof to verify the quality of their work and their opinions. And so when guardians ad litem say that they don't tell us much, if anything, about what the child said, and refuse to provide the evidence upon which they base their recommendations, but instead merely make a recommendation as to what is, in their opinion, in the child's best interest, the evidentiary basis for those recommendations, the factual basis in the record, is literally non-existent. And it's by design, and with court knowledge and endorsement. What verifiable proof of anything pertaining to a child's best interest exists when it comes to custody and parent time? How does a guardian ad litem bring anything to the table in that regard? They literally bring nothing. Why should we take the unsubstantiated word of the GAL over the word of the child directly stated to the judge in an on-the-record interview with the judge? I do not see how a GAL can represent a child when there is no way to tell whether the GAL has done a good, adequate, or preponderance of evidence sort of job, or any kind of workmanship kind of job. The GAL's work and the child's interviews are not made on the record, so we have no idea what was asked of the child or what the child said in response. The GAL is not subject to discovery, so any ostensible evidence upon which the GAL claims to have based his or her analysis and recommendations will not exist as a matter of court record. The court literally takes on faith what the GAL recommends if the court decides to believe anything the GAL says. I ask you, why go through any of this rigmarole when the judge can interview the child directly without any second or third-hand intermediaries, far more quickly, far more accurately, with far more particularity, and more inexpensively than a GAL or custody evaluator?